Should the Eighth Amendment's excessive fines clause apply to the states?
Thank you, and may it please the court. Yes, the Eighth Amendment's excessive fines clause must apply to the states under the Due Process Clause of the 14th Amendment. This court's precedent recognizes, even as recently as McDonald versus Chicago, just less than a decade ago, that fundamental rights guaranteed in the Bill of Rights apply to the states to the 14th Amendment's Due Process Clause. The Eighth Amendment is about as fundamental as a right can get, so it therefore easily meets the test for Due Process Clause incorporation. For example, the excessive fines clause finds its origins as far back as Magna Carta in Great Britain, which has America's common law ancestry. That's where it was derived from, and then a predecessor in virtually the same language of the federal excessive fines clause in the U.S. Constitution may be found in the English Bill of Rights of 1689. So clearly, this right was deemed fundamental to American history and tradition, which follows the Washington v. Glucksberg test of rights that are deeply rooted in this nation's history and tradition must be incorporated against the states. And additionally, it also shows that the freedom from excessive fines is fundamental to the American scheme of justice under the Duncan versus Louisiana test. The right also remained fundamental throughout the 19th and 20th centuries in America. For example, 8 out of the 13 states in 1787 had an excessive fines clause analog in their state constitution. So clearly it was deemed fundamental at that time. And also the vast majority of states in 1868, when the 14th Amendment was ratified, also had excessive fines clause analogs in their state constitutions. So this right clearly meets the test for incorporation under the Due Process Clause under this court's precedents, and it is a straightforward case.
Please explain what Due Process Clause of the 14th Amendment prohibits. Why is it the most appropriate vehicle for applying federal constitutional rights to the states?
Well, the Due Process Clause prohibits the abridgment of life, liberty, and the pursuit of happiness by a state government without the due process of law. And it is extremely important in applying federal constitutional rights for a number of reasons that are historical as well as political and constitutional. For example, if we look at our court's history, privileges and immunities have not necessarily rested on rights. They have referred to certain privileges and immunities that are guaranteed by government, as opposed to rights which are guaranteed by God and the law, according to such documents as the Magna Carta. There's also the longstanding court precedent that prefers the Due Process Clause to the Privileges and Immunities Clause, which is another reason why the Due Process Clause should be prohibited in applying that. Due Process Clause should be preferred in applying this amendment to the states.
So why shouldn't we apply the excessive fines clause to the states via the Privileges or Immunities Clause of the 14th Amendment?
So as my co-counsel noted, the Privileges or Immunities Clause was not, the language of privileges and immunities was generally in the 19th century considered to be separate from the language of natural rights. And it is beyond dispute that the right to be free from excessive fines is a fundamental natural right. As already explained, it was considered fundamental throughout English common law history and remained fundamental in the American tradition. It was not viewed as just a privilege given by government. And well, there are certainly occasional examples you can find from the 19th century where people would refer to fundamental rights as privileges, but in established legal usage, it was much more common to treat them separately. And indeed, noted constitutional scholar Robert Nadelson has found that the Privileges and Immunities Clause, which is a similarly worded clause in the original 1787 Constitution, that clause did not protect natural rights. He said that very explicitly in his research. And so that shows, and there is really no reason to believe that this understanding changed throughout the 19th century down to the adoption of the 14th Amendment. And so it's really not surprising then that there's actually quite a bit of historical disagreement as to whether the Privileges and Immunities Clause would incorporate the Bill of Rights, and there are many who believe that it does not, which is what we believe, but contrary to what petitioner believes. For example, noted originalist scholar Philip Hamburger has found that the Privileges and Immunities Clause only mandated equal treatment among citizens when they were visiting other states and did not incorporate Bill of Rights provisions. Indeed, as Justice Thomas said in 1999, even scholars who believe that the Privileges and Immunities Clause has a broader scope than this court assigned to it in the slaughterhouse cases of 1873, nevertheless do not agree on much more than that basic premise, and certainly not on the incorporation through the due process or through the Privileges or Immunities Clause, I should say. And then there's also the basic stare decisis point of precedent being very important here. The slaughterhouse cases, United States v. Cruikshank, and other cases from the late 19th century very categorically rejected petitioner's theory of the Privileges or Immunities Clause. And to resurrect that would require a special justification that is not present here.
Does it matter which clause part of the 14th Amendment we use to incorporate the excessive fine clause?
Yes, it does. As my colleague here has eloquently pointed out, the Privileges and Immunities in the Due Process Clause use two different standards, and there is a lot of different precedent behind the two different cases. One of the main differences between the Due Process Clause and the Privileges and Immunities Clause is that the Privileges and Immunities Clause prevents the states from infringing upon the privileges and immunities of citizens of the United States. And this would the court would most likely be forced to rule that the Privileges and Immunities Clause only applies to citizens. It does not protect non-citizens. And this has no precedent in our court's long history. One quote from Sanchez Llamas v. Oregon indicates, quote, "Foreign nationals arrested for a crime, like anyone else in our country, are entitled to the panoply of Miranda rights." And for the court to rule that the Eighth Amendment prohibition on excessive fines is incorporated by the Privileges and Immunities Clause could lead to the disastrous decision that decides that the excessive fines clause does not protect non-citizens. Aside from simply throwing the legal system into chaos because you would force judges to rule which provisions do and do not apply to non-citizens, this would enforce a system of chaos on a number of different police officers, a number of different magistrates, a number of different lawmakers who are not as well versed in the law and whose decisions can irrevocably harm and irrevocably help different types of people. And this concern is especially important now, considering that the number of non-citizens in the United States has drastically increased. The number of foreign residents in the United States has drastically increased. And on top of all this, the greater interconnectivity of the world means that non-citizens traveling to and from the United States to conduct business is increasingly important to our nation's economy. And these non-citizens depend on a robust interpretation of our constitutional protections. And if the court were to do anything at all to negatively affect this, it would put at risk the rights of these non-citizens, and it may hurt the U.S. in the long run.
So then what is the scope of the Eighth Amendment's prohibition on excessive fines if we extend it to the states?
Well, under the Due Process Clause, the Eighth Amendment's prohibition on excessive fines would prohibit fines that are excessive, i.e. not exactly in rem forfeitures. In this case, and in all future cases, the excessive fines clause would apply to fines against the person that are levied against the person for crimes committed that they have been convicted of by a jury of their peers. And in rem forfeitures, such as the one at question in this case, would obviously not be at all concerned. In rem forfeitures refer to actions taken against property, and they refer to tactical actions taken by law enforcement and government officials in order to enforce the government's prohibitions against smuggling, and in order to prevent crime, and in order to recoup for lost tax revenues. So the excessive fines clause, if incorporated, would not affect these things in the same way that it would affect a penalty levied against a person for a crime committed and convicted, that they committed and were convicted of.
Okay. So assume that we incorporate the excessive fines clause in this case. Does the forfeiture of Mr. Timbs' vehicle amount to an excessive fine?
No, it does not amount to an excessive fine for several reasons. So first, as my co-counsel sort of alluded to already, the excessive fines clause, both as applied to the federal government and as applied to the states, which have to have the same scope according to recent Supreme Court precedent. So applied to both the states and the federal government, the excessive fines clause only prohibits, first of all, it only prohibits fines, which generally excludes, it does not categorically exclude, but it generally excludes in rem forfeitures against property. Now, this is not to deny that there may not be some cases where an action brought against somebody's property for being involved in a crime is so punitive as to fall under the prohibition of the excessive fines clause. However, this is not such a case. The Indiana state statute at issue here has numerous indications that it is not a punitive statute. And under United States versus Austin, precedent of this court, if a forfeiture statute is not punitive, it is not subject to the excessive fines clause. And basically, the reasons that we do not believe it is punitive are several. So first, the statute makes no exception. In most cases, it makes no exception of property forfeiture, whether or not the person who owns the property was actually the one who committed the crime. So, for example, if somebody stole someone else's car and then committed a crime, the government could still take the car from the original person, even though the original person did not actually commit the crime. So that shows that it's not directed as a punishment at the individual who committed the crime. It's directed as taking away property that has been used to commit crimes. Additionally, petitioner argues that this fine is excessive because his vehicle was worth about $40,000. And while it is true that his Land Rover was fairly valuable, it is also important to remember that petitioner's crime was one that the state of Indiana was entitled to take fairly seriously. There is, in America right now, there's a major problem with heroin overdoses and other problems. So petitioner was convicted under the law for dealing heroin out of his Land Rover. And the maximum sentence allowed under the law for that crime would be 20 years in prison. But he only got just a few years, and then he eventually got all that taken off. So he just got probation. But it's important to remember with that 20-year number, clearly this is something that the law takes very seriously. So it seems like if you can impose that high of a prison sentence, you should be able to impose a $40,000 fine. And additionally, one point, one of the lower courts in Indiana relied, in arguing that it was an excessive fine, they relied on the fact that Indiana has a limit on in personam fines and forfeitures of $10,000. So they said, well, if this is $40,000, that's way too much. But the reality is that $10,000 limit does not just apply to like vehicle forfeitures and stuff like that. It applies to all forfeitures on in personam methodology. So this does not reflect a state judgment that that this particular crime is not serious and does not deserve a heavy fine. Because even if, for example, you murdered somebody the limit on an in personam forfeiture against the person would be $10,000. So this does not reflect, the lower court was incorrect to conclude that this reflects a conscious state judgment that anything over $10,000 would be excessive. Yes.
Okay, so are civil forfeitures ever appropriate as a punishment under the excessive fines clause?
Yes, they are. And in fact, our court's long history and our country's long history shows us that civil forfeitures are indeed fair, and they are completely permitted by the excessive fines clause. Civil forfeitures and in rem forfeitures originated in Old England and continued, whether through the Navigation Acts or through various colonial legislatures, through the 1600s and 1700s until the U.S. declared its independence. And they also used these laws to prevent things like smuggling and piracy in the days of the early republic. They continued to be used throughout the Civil War, through the antebellum period, through the Civil War, and in the period afterwards with no major legal repercussions. And in the period of Prohibition, they were used to crack down on illegal smuggling, and they were used to prevent the loss of government tax revenue as a result of these goods being traded in a black and illegal market that the government has no access to. And they have been used after prohibition of alcohol died away. They've been used in order to combat the smuggling of drugs such as marijuana and heroin and cocaine, and they have showed a good deal of success in that. And the court has never challenged that. They have never disputed the idea that these in rem forfeitures are a necessary measure in order to enforce these laws and protect the public safety. Such a ruling that the excessive fines clause announces a categorical prohibition against all civil forfeiture would lead to the horrible consequence where the government could not seize a $15,000 stash of heroin from Mr. Timbs, even though that property is engaged in an illegal activity, being heroin in that case, simply because the statutory limit on that is $10,000. And that is obviously an outcome that we cannot have here. We can see numerous cases, especially throughout the 20s and 70s and 80s, where the government has rejected the idea of a proportionality requirement here as well. So not only would the excessive fines clause, or at least not a strict proportionality requirement, so not only would the excessive fines clause permit these in rem forfeitures, but the excessive fines clause would not mandate the same kind of prohibitions that say an in personam forfeiture would, because they're meant to crack down on illegal smuggling and stop the black market selling of goods, which harms the government's tax revenues.
So in conclusion, the case for incorporating the excessive fines clause through the due process clause is quite straightforward. Indeed, this court has explicitly observed in a piece of dicta in a past decision, Cooper Industries, that, and I quote, "The due process clause of the 14th Amendment makes the 8th Amendment's prohibition against excessive fines and cruel and unusual punishments applicable to the states," end quote. So this clearly shows that throughout American history, since the 19th century, the due process clause has been the method, and really the only method under consideration, for incorporation of Bill of Rights provisions. And as my co-counsel has discussed, this focus on the due process clause, which protects the rights of all persons, helps make sure that even non-citizens can enjoy U.S. constitutional rights in most cases. Additionally, in addition to this precedent-based argument, so in that the Privileges or Immunities Clause has not been used ever by the Supreme Court to incorporate a Bill of Rights provision, whereas the Due Process Clause has been used several times. But in addition to that, on the historical level, it seems more probable that the Due Process Clause was originally intended by the framers of the 14th Amendment to constitutionalize, or to incorporate, I should say, the Bill of Rights, because, again, privileges and immunities is a very strange way to describe natural rights in the times of 19th century legal thought. And then finally, so the clause should be incorporated to the due process clause. But then we believe that it is not an unconstitutional excessive fine because we believe a fair reading of this court's precedent in Austin compels the conclusion that non-punitive forfeitures do not violate the excessive fines clause. And as explained, this forfeiture it is not primarily or even significantly punitive because it is directed at the property that's been involved in the crime and not at the person who was involved per se. This is certainly not to deny that that fines and forfeitures can have a significant effect on Americans like petitioner. However, the government was entitled to conclude in light of the terrible opioid crisis and other drug problems, it was at least entitled to conclude, whatever your personal beliefs, it was entitled to conclude that needed to be enforced very strictly, and that the car he had used to transport these drugs needed to be taken away. So therefore, for the foregoing reasons, the excessive fines clause of the Eighth Amendment should be incorporated against the states through the due process clause, but this court should hold that the forfeiture of Timbs Land Rover was not an excessive fine prohibited by the Eighth Amendment. Thank you.
Thank you.